And Ms. Corrigan, you're up.
May it please the court. I'm Jody Corrian. I represent the Appellant Kennedy Law Group, and I would like to reserve 5 minutes for rebuttal.
If I may, Ms. Corrigan, your voice sounds faint to me. I don't know whether you could increase your volume.
How is that?
That's better. Thank you so much.
That's okay. Then I lost you. Okay. There are two issues before the court. The trial court should have granted a continuance of the summary judgment hearing because Kennedy Law Group was not able to receive the discovery that had been ordered by the court. And then the court further erred by misinterpreting a partnership agreement between the two law firms. Factually, the case arose Tom Kennedy, Hendrik Udwick, and Eric Abrahamson had worked together for many years. In 2002, Mr. Udwick prepared an agreement to form a kind of partnership between Kennedy Law Group and the Udwick firm, where they agreed that they would share earnings on net collected fees generated by the firm. The agreement also set out what each of the firms would do and their actual operational responsibilities. Mr. Kennedy was responsible for personal injury, pre-litigation investigations and workup of the cases. And then if the case was not settled, it would be transferred to Mr. Udwick for full litigation and trial. At the time they entered into this agreement, they sent letters out to the clients advising them and announcing the arrangement to the clients so that the clients were aware of the arrangement. And they also sent letters out to medical providers advising that the Udwick firm was going to be the Tampa litigation office for litigation and trial. When the files were transferred, and this is important for the discovery issue, when the files were transferred, the Kennedy Law Group would transfer the entire original file to the Udwick firm, so they were not retaining a copy of the actual contracts.
And if I may, Ms. Corrigan, perhaps just to streamline some of this.
Okay.
Let's just set aside the discovery issue. I think if we could jump into the fact that if looking at this agreement, if indeed it is void against public policy, if it's void ab initio, then the whole issue of discovery and all that renders, basically it's meaningless. So let's focus on the agreement itself. The agreement itself, the court found that it was done between attorneys, that it violates the rules regulating the Florida bar. And then and I'm looking at it, it's Florida bar 4- I want to make sure I say it right, 1.5. And basically, because the entire case was based on this unenforceable provision, then the issue of summary judgment and continuing the summary judgment, it really, we don't go there if we have to focus more on the agreement itself. So let's look at the agreement itself and help me out as to why this agreement as written does not violate the Florida rules.
Okay. I would point out that the discovery is relevant for how the parties actually operated the course of dealing over the years, but let's get to the agreement. The case doesn't actually involve a contingent fee agreement or a fee agreement between a lawyer and a client. And what the court found was that it violated the bar rule 4-1.5, which relates to all the manner of fees, essentially. But this was a private agreement between the two law firms. The agreement created a partnership between the law firms, which outlined the operational responsibilities, and the clients were advised when the fees were transferred. No client paid greater than 25% of the fees. So the fee agreement with the clients was in accordance with the Florida bar rules. Each contingency fee contract that was signed was either a 75-25% split as permitted by the bar rules, or there was court approval if there was going to be a greater percentage. The partnership agreement itself required the 33%, but it was based on net earnings of the firm. So it was different from the actual contingency fee agreements with the clients. And this allowed each party to be recovering financially for the work that was put into the case.
And I would appreciate that, but I guess looking at the Chandress case, and if we do know that the rules regulating the Florida bar basically says in excess of the 25% cap, that is impermissible. That's a no-no. But then if you look at the Florida, this is the Florida Supreme Court case of Chandress. Here's what it says. It addressed, even though it addressed different facts, it expressly disapproved an entire line of case to the extent, and this is a language, to the extent that they may be read to hold that a contingent fee contract which does not comply with the Code of Professional Responsibility or rules regulating the Florida bar is enforceable by an attorney who claims fees based upon a non-complying agreement. So that's broad language that strongly suggests the same outcome would occur with an agreement that violates a different prohibition of the attorney's fees as this one does. And so having said this, and what you said earlier, the agreement doesn't mention net fees. So how do you reconcile all of this?
The agreement does mention net fees. It states that the 33% would be paid on net collected fees, which are obviously as a law firm.
On an annual basis. Is that correct?
You know, it didn't say how often. What would happen was they would meet monthly and kind of do a reconciliation.
Okay. But I mean, you know, so you've got individual cases, you got a 25%, but at the same time, everybody knows that at the end of the month, it's going to go up to 33, correct?
Correct. But not all of the cases are standard 75-25 contingency fee cases. There were also admiralty cases involved.
But other cases were, but those cases were included in the 33, were they not?
Yes, yes. And I would like to point out that Chandress was decided in 1996, and I pointed this out in the briefs. The bar rules have been amended, specifically Rule 4.1.5 has been amended 13 times since Chandress, and yet the rule still does not specifically address a situation like this. The preamble to the rule, the comments to the rule still state that the validity of a contract is not subject to whether it complies with the bar rules, and that the rules are not intended to be, this is in the comments, are not intended to be procedural weapons or defenses used by others, allowing parties to assert non-compliance with the rules as a defense, whether the fee is fixed or contingent, allows for potential inequity if the opposing party is allowed to escape responsibility for their actions through the application of these rules. And one of the cases that we cited in the briefs was the Mark J. Kaufman case, which I acknowledge fully. It was decided prior to Chandress. It was decided, I think, in 92. And that's probably factually the closest case we have to what happened in this case. Most of the other cases involve a dispute between the lawyer and the client, and the bar rules are intended to protect the client from unscrupulous lawyers. But in the Kaufman case, what happened was Mr. Kaufman was very ill, and his firm, the Kaufman firm, had filed for bankruptcy. As part of the bankruptcy, they agreed to transfer 45 of the firm's cases to another firm, the Davis law firm, for prosecution. And they agreed to split the fees on those transferred cases 50-50. The agreement was actually approved by the bankruptcy court, and the cases went along. When one of the cases was settled, Mr. Kaufman came back to the Davis firm and asked for the 50% of the fees. And the Davis firm basically said, no, the contract because of the percentages, the contract violated Rule 4-1.5. We don't need to pay that. And the first district found that even though the contract violated the rule, Davis could not rely on that to avoid its obligations. And it cited the preamble to Chapter 4 of the Rules of Professional Conduct. And it stated that the rules are designed to provide guidance to lawyers and to provide a structure for regulating conduct through disciplinary agencies. They are not designed to be a basis for civil liability. Furthermore, the purpose of the rules can be subverted when they're invoked by the opposing parties as procedural weapons, as was done in this case. The first district concluded that it was an error to use an ethical rule to invalidate a private contract between two parties. And that's essentially what we have here, is that we're using an ethical rule to violate, to basically invalidate a contract that was an agreement between the two parties. And as I said, I recognize that this case was decided before Chandress, but what is undisputed is the fact that the Florida bar has not changed either the comment or the preamble to the rule that set forth these establishes. So essentially, Chandress takes a Florida bar disciplinary rule and essentially kind of elevates it to a functional substantive rule of law, which they are not intended to do. And this was pointed out by Judge Sasso in the Harmon Parker case. In her dissenting opinion, she agreed that the scope of Chandress, with that sweeping statement that any contingent fee contract, I lost my notes here, agreement that does not comply with the rule is void. She agreed that that statement is too sweeping and it was not intended to cover everything that it has been used to cover. And she also cited the preamble to the rules, stating that the rules are not to be used as a weapon. And she believed that technical violations did not render the agreement enforceable. So as I said, this is not an agreement where a client is hurt in any manner. This is not something where the client did not get what they were supposed to get. This is simply an agreement between two law firms that work together and refer cases back and forth and transfer. The Kennedy Law Group would perform a lot of pre-suit investigation and witness a lot of work before it was transferred. It's not like they signed up a client, sent over the case, and that was that. I'd also point out,
before you run out of time, this going on, because in the record, it appears that at least based on the affidavits, based on the deposition testimony that were presented, two of the signatures of this agreement indicated that this agreement has never came to fruition. That this agreement, yes, no one followed that. And so how do you reconcile that?
Well, I think that kind of goes back to why the discovery issue was very important, because Mr. Merrick's, who had signed, he was one of the signatories for Kennedy Law Group, and Mr. Barnes had signed for the Udwick firm. Mr. Merrick's wasn't employed much more than a year after that, right? So they weren't necessarily involved in this over the years. And that's why we had requested the discovery to see the actual litigation files. It was ruled that we were entitled to see those files. There were 668 files, I believe, and the judge had ruled, 9 days before that Kennedy Law Group should be entitled to look at those files to see what the notes were, to see what the conversation records were, to see if there were emails between the parties describing how this agreement actually worked in practice over the years. The only evidence we have in this case, and the other side has made a big deal about the fact that it's self-serving testimony of Mr. Kennedy. Well, the only people that really understood what was going on were Mr. Kennedy, Mr. Udwick, and the files. And Mr. Udwick is deceased, so obviously he can't be here to testify, which is why the files would be helpful to actually see what went on between the parties. I also want to point out one other thing that the judge had mentioned in his order as to why he did not believe this agreement was valid was because of what happened when the Kennedy Law Group had filed for bankruptcy. And I wanted to point out, it is in the record that Mr. Kennedy testified that Stichter Rydell, a well-respected Tampa firm, was his bankruptcy counsel in that case. And they were the ones that prepared the forms that were submitted. And also the failure to list this partnership agreement as an asset in his divorce. Once again, he was represented by counsel. At a point in time after the divorce, his former wife had filed a petition to reopen the divorce and arguing that because he had received a large verdict, a fee from a large verdict in one of the tobacco cases, that she was entitled to that. And the testimony was, and this is all in the record, pages 1347 to 48, a forensic accountant that was involved in the divorce, he filed an affidavit stating that contingency fee cases are not considered assets for the purposes of an equitable distribution in a divorce. And that's why that was not filed.
So basically taking the position that he was relying on counsel, and that's the reason why it was not mentioned, as opposed to the fact that it was there, and if it was truly a partnership that would have been listed in the bankruptcy. This is your position, Ms. Corrigan?
The position is that he did rely on counsel, and the position is also that the litigation files would be evidence of the partnership that we simply don't have because we were denied the right to actually get the discovery before the summary judgment hearing.
Okay, and because you still have your time, I want to be able to have you address one of the issues that the appellees brought out. You keep saying that you wanted to do more discovery, but you also moved for summary judgment. And how do you reconcile the fact that you were ready to proceed with summary judgment, and then now you're indicating, oh no, it needs to be continued in order to submit and to do more discovery?
The comments to the rules on summary judgment state expressly that just because you move for summary judgment and state that there's no disputed issues of fact based on your theory of the case doesn't mean you can't assert that there are disputed issues of fact if the other side moves for summary judgment on a different issue. We moved for summary judgment believing that the contract is valid and that it should just be enforced according to its terms, and that was the basis of the summary judgment. The opponent, when they moved for summary judgment, they brought up the fact that the contract was abandoned and it didn't exist and that nobody operated by it. And that's why the discovery became so critical, was if they were going to dispute that the contract existed at all, we needed the discovery to be able to refute that claim.
Okay, and Ms. Corrigan, you're right at your rebuttal time. So use your 5 minutes as you wish.
I guess I'll reserve it for rebuttal.
Sure.
Thanks.
Your Honors, may it please the Court. My name is Brent Steinberg. I'm with Swoper Dante, and I represent the appellees in this action, Hendrik Udwick, PA, and Vicky Udwick as personal representative of Hendrik Udwick's estate. Your Honors, we're asking the Court to affirm Judge Farfante's summary judgment order for 3 reasons. First, Judge Farfante correctly held that the purported partnership agreement was void ab initio because it called for a division of attorney's fees that would have violated the Florida bar rules. Second, he correctly held, and this wasn't even addressed on the initial time for my opponent here, he correctly held that plaintiff's claims were time barred because the plaintiff was on notice of the alleged breach in 2003, but waited more than 18 years until after Hank Udwick died to first complain about it. And then third, Judge Farfante did not abuse his discretion in denying defendant's motion to continue the summary judgment hearing. Now, Your Honors, I want to address each issue, but at this point, I would ask that we take a step back. Let me give you a little context about the underlying dispute here. I think this might answer some of your questions, Judge Kuzam. So, Kennedy Law Group filed this lawsuit 2 months after Hank Udwick died, almost 19 years after Mr. Udwick's and Mr. Kennedy's firms allegedly formed a secret partnership agreement. And this lawsuit is not only against Hank Udwick, his old firm, but it's against his widow, Vicky. And in this lawsuit, Kennedy alleges that Hank Udwick's law firm had been breaching the purported partnership agreement for decades, that Hank Udwick, PA should have paid an additional 8% contingency fee on every referred case. And importantly, it's not net earnings of the firm, it is on the referred cases is what the agreement calls for. And the first time that Kennedy ever made these allegations was in the complaint itself. Not once while Mr. Udwick was alive did Kennedy ever complain about this alleged breach of contract. Now, it is absolutely undisputed that in 2002, June 28th, 2002, attorneys Hank Udwick and Steve Barnes on behalf of the law firm then known as Udwick and Barnes, and Tom Kennedy and Howard Merricks on behalf of Kennedy Law Group, that together the 4 of them executed an agreement to form a new law firm. And that new law firm was supposed to start on January 1st, 2003, and was going to be called Kennedy, Udwick, Merrick, and Barnes. But that new law firm was never formed. It is undisputed that there has never been a legal entity called Kennedy, Udwick, Merricks, and Barnes. And Mr. Barnes and Mr. Merricks, both of whom were vice presidents of their respective firms at the time, they both testified in this case that the partnership between their two firms never got off the ground, essentially that this June 2002 agreement was abandoned shortly after it was signed. There are no documents reflecting that Hank Udwick's firm operated as if it were in a partnership with Kennedy Law Group from 2002 through 2021, as Kennedy alleges. If this partnership existed, it was not reported to the IRS. There were no Schedule K-1s or other tax documents that you would expect to see if this was a partnership. We mentioned in 2009, the Kennedy Law Group filed for Chapter 11 bankruptcy, and it did not disclose the existence of it in that proceeding. And at page 2038 of the record is the specific schedule asking the disclosure of any partnership interests that Kennedy Law Group would have had to disclose to the bankruptcy court. It's not there. The divorce proceeding in 2013, in that proceeding, they were looking at all of Mr. Kennedy's business interests when determining the amount of alimony owed. And it wasn't just contingency fee cases, it was asking for partnerships at 2059 of the record. And again, Mr. Kennedy did not disclose the existence of this alleged partnership. So all the record evidence other than Mr. Kennedy's self-serving testimony indicates that the parties abandoned this agreement shortly after they signed it. But critically, Judge Farfante avoided making any ruling on whether Mr. Kennedy's story is to be believed because his summary judgment order assumes that what Mr. Kennedy said was true, that they really did have a partnership agreement. However improbable it may seem, the Hank Udwick PA and Kennedy Law Group had a deal that they kept secret from their mutual clients to divvy up fees in a manner that was different than the contingency fee contracts themselves required. Assuming that deal existed, Kennedy Law Group's claims fail as a matter of law. They fail as a matter of law because the partnership agreement was void ab initio, because it called for a fee split that is prohibited under the rules regulating the Florida bar. So the June 2002 agreement called for Kennedy Law Group to receive 33% of the attorney's fees on every case it referred to Hank Udwick PA, not 33% of all net profits, 33% of each referred case. But every time that Kennedy Law Group referred a case to Hank Udwick PA, there was a contingency fee contract with the client. And it reflected the existence of two separate law firms, and in all but 3 of those contracts, they called for a 25% contingency fee to be paid to Kennedy Law Group. And in every one of those cases, 25% was the amount that was paid to Kennedy and accepted by Kennedy, as reflected in the closing statements that were signed by the client. And in the 3 outlier cases where Kennedy was paid more than 25% because of the level of work that it performed, well, in those cases, they obtained court approval as required by the rules. So what Kennedy is asking this court to do is ignore the plain language of those contingency fee contracts and instead find that Hank Udwick PA owed an additional 8% contingency fee on hundreds of cases going back 19 years, even though that 67-33% fee split was not only never court approved, but was never disclosed to the clients. I don't know how any Florida lawyer handling contingency fee cases could possibly think that that is okay. You can't tell the client one thing about attorney's fees and then secretly do something else. And Judge Farfante, he recognized this. He correctly ruled that any such agreement, assuming it existed, would be void as against public policy.
And that's the key, Mr. Steinberg, because if we come to the conclusion, if we agree with Judge Farfante that this agreement is void ab initio, the whole issue about discovery, that just renders that moot.
Agree, Your Honor. The discovery issue would have gone to whether or not the parties were operating as if the partnership existed. And Judge Farfante's ruling is, even if we assume that that partnership existed, it was illegal, that you cannot split fees in the manner called for by this partnership agreement. So we look to Rule 4-1.5, subsections F and G, okay? These are the sections governing how fees are to be shared among lawyers in contingency fee cases. And under F4D3, the only time a referring lawyer may charge more than 25% is if the firms accept substantially equal active participation in the providing of legal services to the client. And in those circumstances, the law firms must, not may, must obtain court approval based on a sworn petition signed by all counsel, and the clients have to be served with that petition. And then you go down to G. G also governs a fee split between two different law firms. And for a specific fee division different than 25% or above 25% to be allowed, one of 2 things has to be true. Option 1 is that the fee percentage must be in proportion to the services performed by each firm. And option 2 is that the client contract itself, each lawyer has to expressly assume joint legal responsibility for the representation. They have to agree to be available for consultation with the client, and they have to fully disclose the division of fees and the basis on which the fee division will be made. And the June 2002 agreement didn't do any of that. It was not court approved. It did not contemplate the parties providing substantially equal active participation. What was described was just a straight up referral relationship that Kennedy would send the cases to Udwick. There is no record evidence that 33% of the fee would be in proportion to the services performed by Kennedy Law Group as compared to Udwick's firm. And most importantly, the written fee agreements with the clients called for a 25% contingency fee, not 33%. So what we have here, if Kennedy's to be believed, is a deal that was kept secret from the clients, calling for a fee division that would be illegal in the absence of court approval and full disclosure to the client. And that is unenforceable. And we need to look no further than the Harmon Parker versus Santec case, okay? This was a second DCA case. It was rendered by 5th DCA judges sitting by designation, which is how Judge Sasso wrote the dissent. But it is in fact a second DCA case arising from Sarasota. And I know this because it happened to be my case and I handled the appeal. And it was a dispute about the division of attorney's fees between two plaintiffs' firms. And the subject fee agreement in that case was actually court approved. But the court said that there were deficiencies in the fee approval process, which were substantial and significant. So even though there actually was court approval in the Harmon Parker case, the court said it was still bound by the Chandres decision from the Florida Supreme Court, and that the second DCA held that the fee splitting agreement between the two firms was void as against public policy because of the deficiencies in the approval process itself and was therefore unenforceable. Now, both Chandress and Harmon Parker are binding on this court. And
I just want to ask you, Mr. Steinberg, Ms. Corrigan's taking the position that Chandress is old, the rules have changed, have not really changed, superseded, then that's not good law. What is your position on that?
So, I mean, that is in essence what the dissent was saying would be the better reasoned result. But because Harmon Parker is a second DCA case, it is binding on this panel. You can't recede from Harmon Parker in the absence of en banc review. There's no basis to do that because the rule says what it says. And if you violate the rule under Chandress, then it is unenforceable. And the situation here is so much worse than the Harmon Parker case. I mean, Harmon Parker, they had got court approval. What we're talking about is a deal that was kept secret from the clients, that was never court approved, and basically that the clients were lied to about how the attorney's fees division was going to work. I can't imagine any court endorsing that. Now, there's also a bar ethics opinion that I would ask the court look at and should be persuasive that we cited in our answer brief. It's 93-6. Talks about how a joint venture of this nature would be illegal. And Mr. Udwick was aware of this opinion because 2 years earlier, in June 2000, attorney David Manny had given it to him, and that's in the record at 1988. And the bar opinion explained that you can't have two separate law firms engaging in a joint venture to get around the 75-25% fee split in the rule. And then it goes on to explain that you can't run a parallel firm. And the example it gave was if Smith and Brown were to create a second wholly owned PI firm and then pretended that that was a separate firm and represented to clients that this is a separate firm, well, you can't do that because it'd be misleading to clients, and then clients are entitled to know the true nature of the law firm that's representing it. And if Mr. Kennedy's story is to be believed, what he's saying is that the parties were engaging in this unethical practice, because his most recent testimony, which has changed over the years, but most recently testified that Hank Udwick PA was effectively a subsidiary of Kennedy Law Group, and its lawyers were secretly practicing in both firms. Now, again, the only evidence supporting that is his self-serving testimony, but if it were true, that would be a parallel firm prohibited by the opinion. So the June 2002 agreement called for the creation of a new law firm. That never happened. Had that happened, it would be a different situation, but it didn't happen. And the bottom line is that the trial court correctly held that the fee sharing provisions were unenforceable. Now, on the second issue about whether the claims were time barred, the court made no error in finding that the claims were time barred. It wasn't even raised as error in the appellant's initial brief or in the initial presentation. It wasn't until the reply brief that they said anything about the court finding, which is at page 2525 of the record in paragraph 10 of the order. And the record reflected that if the June 2002 agreement was effective, that Udwick breached it almost immediately. Kennedy would have suffered damages almost immediately, because Udwick did not refer cases to Kennedy as contemplated in the agreement, and Udwick did not pay 33% contingency fees on every referred case. And the court found that Kennedy was on notice of these alleged breaches in 2003, and appellant has not met its burden of demonstrating error. And just to quote Judge Farfante, there are no circumstances under which any court could award attorney's fees for over 20 years of closed cases in which the contractual amount of the fee was paid. I don't know what else to say about it beyond that. Finally, on the motion to continue issue, Judge Farfante did not abuse his discretion. First of all, the motion wasn't supported by an affidavit as required by Rule 1.510D, which the purpose of the affidavit is to allow the non-moving party to explain why it can't present facts essential to justify its opposition. So the motion's facially deficient. Second of all, the hearing on the motion to continue was apparently not transcribed by a court reporter. And appellant made no effort to recreate the record as permitted by Rule 9.200. So the record is actually silent as to why the court denied appellant's motion. And I don't know how anyone could ever meet the burden of demonstrating an abuse of discretion when we don't know why the court ruled the way that it did. But say you get past those two threshold issues, each of which should be fatal, the argument on the merits fails. And as observed, Judge Kuzam, they were talking out of both sides of their mouth. On the one hand, they're seeking summary judgment on the same legal issue, that there was a contract that was breached, and they were arguing there are no disputed issues of material fact. And on the other hand, they're saying they need additional discovery to reveal the existence of a material issue of disputed fact. And what they were actually asking for was additional time to allow an expert to conduct electronic discovery of an additional 668 client files, that the court ruled that they were entitled to do that 9 days before the summary judgment hearing, and I guess 9 days was enough time. But as they admit in their initial brief, the discovery was related to the parties' relationship and the course of dealing, and that would only be relevant to the issue of whether the parties operated as a partnership. And Judge Farfante did not rule on that issue. His order says that even if we assume that the agreement was effective or that it had not been abandoned by the parties, well, it's still unenforceable and the appellant's claims are time barred anyway. And there's nothing in the client files that would be relevant to that issue, meaning that even if you thought Judge Farfante somehow abused his discretion, any error would be harmless. But he didn't abuse his discretion. The discovery was a fishing expedition. It had nothing to do with the issues that formed the basis of the summary judgment. And there's nothing in those files which is going to reveal that the June 2002 agreement was not void as against public policy, or that the claims are not time barred. So there's no basis to reverse on that as well. So, Your Honors, I mean, unless you have any additional questions for me, I would just respectfully request that the court affirm in all respects.
Thank you, Mr. Steinberg. And Ms. Corrigan, you're up for a 5-minute rebuttal.
Thank you. The statute of limitations issue, we did argue this in the brief. We had argued it at the summary judgment that the items that they said were considered breaches of the contract, the failure to create a new firm in 2003, it was a breach because we believe that the provision of the agreement, I believe it was paragraph 6, basically was self-executing, and that just kind of came into being, this operating as a partnership. You didn't need to create a new firm, which candidly, if we had created the new firm, that might get into the problem of having a parallel firm situation. Specifically regarding that ethics opinion, that's one of the reasons why.
Well, let's go back, Ms. Corrigan, because I want you to address, because it's been 20 years, and 20 years after the fact, how do you reconcile that? And I see here, and I pulled up Judge Farfante's order, and he does say, in no uncertain terms, that how can any court award fees for over 20 years of closed cases? How do you respond to that?
We did respond to that in our brief. We're not, obviously the statute of limitations would have run for 18 years ago. What we talked about is the fact that the more recent issues. So the statute of limitations for the breach of contract claim would be the 5 years. So 5 years from filing the lawsuit, 5 years earlier, those claims would still be valid. And we aren't suggesting that they breached the agreement. Payments were being made over the years. So we're not the ones saying that it was breached 18 years ago. We're saying that it was breached in the past few years. And specifically what happened was Mr. Udwick had a stroke and was incapacitated in the fall of 2020. And that's when things really started to go awry, because he was no longer the person basically managing the firm and making the decisions. That's when the firm started to take the tobacco cases, many of which had been provided by the Kennedy Law Group, they started taking those cases and kind of shopping them to other firms and transferring them. These are the things that we allege were breaches. We did not allege that there was a breach back in 2003 for failure to form a new firm. We alleged breaches that were current, within the last 5 years that would not be barred by the statute of limitations. So that's plainly not true. As far as that ethics opinion, no dispute that that ethics opinion was provided to Mr. Udwick, which is one of the reasons why we believe that the way he structured this agreement was specifically to avoid the problems of that ethics opinion, was to make this not fall into the trap of what was wrong in that case. And we believe that that's what he attempted to do and had actually done. 1 second. We go back to the void ab initio, and I go back to what the preamble, what the disciplinary rules state. And I'm not saying that Chandress should be overruled. What I'm saying is that this case does not fall specifically within the Chandress decision because it is not a contingent fee agreement. There's no client that was harmed by this. And we fall much more plainly within the scope of the Kaufman case, which I did shepherdize last night, thinking, okay, if there's going to say something that this has specifically been overruled or something, and it's not. It has been.
And Ms. Corrigan, I just want to make, you're taking the position that a client has to be harmed in order. Is that because you keep saying that over and over again? I want to make sure that if you have a rule that says this is not okay, this is not okay. And this is the rule regulating the Florida bar that the Supreme Court has a hand in it. So I just want to make sure I understand. Your position is that if the client is not harmed by it, that lawyers could just enter into whatever agreement, 60%, 80%, 90%.
No, I'm not trying to be flippant about that at all. I think the bar rules are there for a reason, but I also think that the case law states that a contract is only void against public policy when the interests of some public interest is contravened or somehow hurt. And when you look at the fact that the rules have been amended so many times since Chandress and still don't specifically address this situation, and yet still provide for the fact that you can have an agreement and still have it be enforceable, even if you have technically violated the rule, I think this is something that a court should address. And maybe that is you and maybe it's not, but I believe that it's something that should be addressed for all lawyers so that they know where we stand on these types of issues. So I would say that once again, it was not a contingent fee contract expressly governed by Chandress, and the preamble to the rules continue to state that the rules are not designed to be used as a weapon in civil litigation. And I would ask that the court reverse the decision and send it back to the trial court so that we can get the discovery and see how the agreement played out over time. Thank you.
Thank you, Ms. Corrigan. Thank you both very much. In order to leave our virtual courtroom, you need to look for the button in the lower right-hand corner of your Zoom screen. It either says leave or it's a pictograph of a figure going through a door, depending on which version of Zoom you have. But when you click one of those, you'll go off into the ether.
Thank you.
Thank you, Your Honors.
Thank you now.